My name is Brent Vassar, President of the McCracken County Bar Association, and I would like to welcome you to the People's Law School. The People's Law School is a program of instruction presented by local lawyers who have volunteered their time. The participating lawyers have many years of experience in the areas of law about which they will be speaking. However, the viewer is cautioned that no advice is intended to be given during the discussions. We recommend that each of you consult a lawyer on a face-to-face basis concerning the merits of your particular case. With that in mind, we hope you enjoy the presentations.
Hi, I'm Cynthia Sanderson, Family Court Judge in McCracken County, and this is the People's Law School for 2009-2010. Today we have John Reed, an attorney here in Paducah, as well as Jeff Alford, and we're going to be talking about domestic relations law. John, recently there has been a case come down from, I believe, the Supreme Court of Kentucky, the name being Pennington versus Pennington, that does a little changing in what we have been used to in our domestic relations law. Would you like to tell the audience about that new law?
Sure. The case basically stands for the proposition that custody does not mean possession of a child, which I think most people feel it does, and probably even a lot of lawyers believe that it did. That custody refers solely to decision making for a child. And so, of course, the courts, your court, but even courts before you, have been granting joint custody when both parents are good parents and good people. Courts have routinely granted joint custody, but typically the court made one parent what we would call the primary residential custodian, and so that would be the custodian where the child normally resided. More recently, in Pennington, they say, well, we shouldn't call anybody a primary custodian, because if you have joint custody, you both have equal decision-making rights toward your child. And then what they've done then is separate out from decision-making, which is custody, parenting time, which is the time you actually spend with your children. And so the concept is sort of new, particularly for us in Western Kentucky, because we've been more traditional, I think, through the years with having a custodial parent where the child normally lived and a secondary custodial parent where the child visited, with regular visitation and dividing holidays and summer. And the importance of the case, I guess, for lay people, particularly those who have already been divorced, is that as I read the case, the rules are now more relaxed to be able to come in and ask to change the parenting time you have. So I know you've seen a lot of these already. I've had some myself. Situations where maybe people agreed to some arrangements a few years ago when one worked every weekend. Now that person has a different job. They don't work every weekend. So used to, they didn't visit on the weekends. Now they're off on weekends. They want some weekend time, so those folks come in. And then the case was decided in the case where a person was relocating. And that's the case actually, I guess, at its core stands for the proposition that if you've lived in the same community, you've been divorced, and one parent, the children primarily live with one parent, if one of the parents decides to move, particularly that parent where the children have normally lived, then either parent can go back to court and say, hey, wait, I think we should change and adjust this parenting time. So if mom's going to move to Nashville, dad may say, the kids are happy in school here, they've always lived here, we've got extended family here, and I think it's better for the children to stay here. And as I read the case, you've got to decide what's best for the children, not what's best for each parent.
Yeah. In the past, Jeff, it's almost been as if a primary caregiver could just up and leave when they wanted to relocate without asking permission of the court. Is that how you've seen how the law has worked in the past? And if so, how has Pennington changed that specifically?
I think that's definitely how the law has worked in the past. As a matter of fact, there's at least one judge that I routinely practice in front of here in West Kentucky that kind of has a rule of thumb that if the primary custodian is moving 150 miles or less from where they're currently residing, he pretty much will just automatically accept it without the other parent being able to come in and challenge that. I think that what Pennington does is it puts the onus on the custodial parent, if they're intending to move, to notify the other parent of that intended move, and give that the other parent an opportunity to come into court and to challenge it under Pennington. You know, interestingly, I think Kentucky historically has been much more lax in allowing a custodial parent to relocate and to move with the child than other states have been. I practice over in Illinois as well, and you actually have to, it's by statute, you have to get court permission if you want to move outside of the state of Illinois. And if you don't do that, those judges will routinely change custody.
Do you see it as the case requiring permission to move from this date forward?
I would tell any client that came in if they were going to move, you should be first to file the motion, be proactive. You know, obviously first you call your ex-spouse and say, can we work this out? And if they say, no, we're not working it out, then I think the person who wants to move should be the proactive one and file. Now the case says either party can file, but as we all know, whoever files first will get to put on their evidence first. And try to convince you before the other side even gets a chance to go that this is probably a pretty good thing for the family.
Right. When you mentioned that the standards for changing custody have been relaxed somewhat under this case, what specifically were you talking about?
Until this case came out, the statute says that if you've had a decision within 2 years, a custody decision, you could not change that unless there was serious endangerment. And fortunately, serious endangerment does not arise very often. I know it arises once in a while, but for most people that's not an issue.
Could you give an example of what serious endangerment may
It would be
maybe?
that someone's abusing the child, that someone's neglecting the child, that someone's not properly caring for the child. You know, they're sending the child malnourished to school. We see it, you see it, I know, more than I do. You see it with the case of drug moms who get hooked on drugs, and so they just quit taking care of their children. Their children just sort of have to survive on their own. They don't get to school, they don't get fed. And there are cases that say serious endangerment means serious endangerment. It doesn't mean, oh, I didn't like those shoes that little Johnny was wearing, or that shirt, I didn't think that shirt was quite as nice as what little Susie should have, or blouse little Susie should be wearing, because we've had those cases through the years where people came in, they just didn't like the way the other person parented. But serious endangerment meant it had to be a really serious situation, which meant that typically you just didn't change custody
within that 2
within
years?
2 years.
It's almost a finding of unfitness.
Right. It is a finding of unfitness, really.
Yes, it seems to be comparable to that. And so the Pennington case relaxes that standard to a best interest standard, which is the standard after the 2 years at least.
Right.
As I say, I think Pennington just simply says, Dad can live in Paducah, Mom can live in Nashville, and they can still share in decision making because we all have phones, cell phones, computers, emails, so major decisions you can always share in. So they're saying that unless you're trying to take that decision making away from someone, if you try to change that, you're still got the 2 year issue. But if you're willing to share decisions, then if you're just talking about where's the child going to normally reside, you can bring that motion anytime you want to.
Okay, so for our audience that's listening to all of this, let's be more concrete, and I'll give you an example. Let's say in the hypothetical world, Mom has custody, Dad has joint custody with her, but she is the primary or the residential custodian under the old law, and Dad has visitation, say on weekends. She wants to move. It's been within a 2 year period of that original custody order that granted her that primary custody. She wants to move and Dad doesn't want the child moving. What could be the outcome of that if he brought her to court or she came to court requesting permission, and a simple matter of everything looked pretty good, but the child was really connected to this community and really didn't know that many people in the new world that he was about to enter into?
I think in that situation, and I'm glad you added the additional facts, because the first thing I was going to point out is I think it's going to depend on how far is Mom moving, because I think that, and I've got several clients in cases where, parents are living within a couple of hours of each other. That's not insurmountable to still do a weekend visitation exchange. But for example, if mom was moving from Paducah to, say, Washington State or something like that, I think that under the Pennington case, if the child has extremely strong ties to this community, doesn't really know anyone at the new place where mom is wanting to move, I think if you can establish that mom is perhaps even moving to try to frustrate dad's time with the child, I think Pennington says that the court's going to have to change the parenting time so that the child continues to primarily reside here.
But I think Pennington also says even if you're just moving to Nashville, the court could find that both parents were really good parents to start off with. They were almost, or maybe they were equal in parenting ability, and the child is happy here. The child's well adjusted, never lived anywhere except Paducah, Kentucky, has grandparents here, has aunts and uncles. The court could just as likely, depending on the facts, say, I'm sorry, Mom, you can move. I can't keep you from moving, but I'm gonna change the parenting times. I'm gonna let the child normally reside here, and you'll be the one that sees him on weekends, and maybe we'll try to give you some extra time in the summer.
I think that's true. I think it comes down to the different facts of the case as to whether or not the child can continue to maintain those same strong ties if mom was allowed to move. I guess the long and the short of it, it comes down on a case-by-case basis, like a lot of these cases do, and it's hard to give a one-size-fits-all answer.
I absolutely agree. I've always said all divorce cases are like snowflakes. No two are alike. And they all have separate facts, and no children are the same. So you're dealing with different children. No parents parent exactly the same way.
Right.
So you're always looking at the judge, what's in the best interest.
What's happening on the front of grandparent visitation? Anything new?
Well, there was several years ago, the U.S. Supreme Court struck down most states' grandparent visitation statutes, and I tell clients that essentially grandparents' visitation at that point became impossible to get. But then Kentucky back, I think about 2004, 2005, came out with a case, the Vibbert case, V-I-B-B-E-R-T, and set forth several elements that can be established in order to grant grandparent visitation in a situation where a grandparent has played a particularly vital role with the children, more than just little Johnny comes to spend the night every couple of weekends or something like that. And so at that point, I think grandparent visitation went from being impossible to get to just becoming somewhat hard to get. I think the court is still going to have to take a look at is a fit parent still has the right to deny visitation to grandparents, and the onus is on the grandparents to come in and prove that it's in the child's best interest. Again, we're going back to the best interest standard, that the child should be allowed to visit with that grandparent.
I think one thing we should make clear, though, because a lot of people have this misconception. If both parents, my perception, you correct me, Judge, you make the decisions, my perception is if both parents have some form of visitation, then you expect the grandparent to visit on their child's time. In other words, if it's my grandson, you expect me to visit when my daughter has my grandson. And you're not going to just let grandparents come in and monopolize a bunch of time and take it away from parents. And that where this issue really comes up is where a parent's deceased, a parent's moved away, or for whatever reason a parent simply can't exercise their visitation, and then the grandparent wants to come in to maintain that contact with the child.
Well, I do see an occasional case where there is conflict between a grandparent and a child, such that the grandparents are being cut out of the loop and no longer allowed to see the child, and there's animosity that is fueling this problem more often than not. And those are difficult cases, and usually not turning out favorable to the grandparent, because in this climate, parents still have a right to raise their children the way they see fit, and the grandparents got a huge burden to prove that it's better for the child to go with the grandparent at times against the parents' objections. That's a hard one to prove.
And I think that's the Supreme Court case where they sort of struck down grandparents' rights, I think arose out of that situation of where the child, the parent of the child was estranged from their parents, and they didn't want their parents to have anything to do with their child. But those are heartbreaking cases, as are the cases, I think, of where a spouse dies, and then the surviving spouse doesn't want the other side's grandparents to have any visitation with the children. I know you've had some horrible cases like that in the court for years, which I think are really sort of gut-wrenching, because that grandparent not only lost their child, they lose their grandchildren too.
Yeah, that is unfortunate. Let's talk about being reasonable. How important is being reasonable in these cases?
I always tell my clients that that is vital to their case, not only to their case, but also to ultimately to their happiness in a post-divorce world. I always try to impress upon clients that family law litigation, custody litigation, it's much more intense than what I would say a normal fender bender type case would be, where you're just suing over money damages. And the reason I think that is because, in a car accident case, for example, you're not going to have everything that you've ever done in your past, every bad act brought out into the light and harped on in open court, where friends and neighbors and relatives can be sitting there hearing all about that. It's very intense, and I always try and make sure that before anybody decides that they want to pursue custody of their child, that they truly believe in their heart of hearts that it is in their child's best interest. That being said, again, being reasonable will not only make their lives easier being reasonable with the other parent as far as trying to come up with some sort of resolution, it will make their case be resolved much, much, much quicker and save themselves a lot of money in time and fees. It will make their children happier. It makes the court happier. There's nothing worse than going into court and knowing that the judge does not like your client.
The only problem with that, and I agree with everything you said, but it takes, in a divorce, two people to be reasonable to get the case resolved reasonably.
What about
Apologize, I have a head cold.
what about after a divorce is over and the case has been resolved, and then the parties start being unreasonable in their time sharing that's established by the court order and so forth? Maybe it's not crystal clear, or maybe it is crystal clear, and the parents are just being unreasonable toward each other, one being unreasonable toward the other. What are your suggestions to that parent who's taking the brunt of the unreasonableness?
Well, one of the things, of course, the court system is doing is you're basically requiring, in almost every case, people to go to mediation. And I think the whole point of a mediation, where you have a third person, a mediator, who's trying to lead the people into an agreement that they can all get along with, that whole concept is based on being reasonable. You have and you don't have a lawyer there typically. Sometimes we have lawyers, but sometimes not. But typically what you're trying to do is get across the mediators, and Jeff does a lot of mediation since he's a very good mediator. Typically, I think Jeff is trying to get across the point when he's a mediator, you don't want to be unreasonable. You can settle this thing and be reasonable and maybe get a little of what you want. But if you're totally unreasonable, you're going to go to court and you're not going to get anything that you want. So why don't you compromise some here with something that's not as important, and then and then maybe you'll get what you want over here. Say that the only problem with all this concept is, we know this from our practice, you know it from court, there's some people who just don't have a reasonable bone in their body. And I tell my clients, one of the things clients love to ask, what is a divorce going to cost? I have no idea. I don't know your soon-to-be ex-spouse. If they're reasonable, it won't be that bad. If they're unreasonable, the sky's the limit. So, and sometimes, I will say, the cost sometimes brings some people back to some degree of reasonableness.
That's definitely true. I think also what happens in a post-divorce situation is that the parties, they've built up such animosity over the course of the divorce case. It's almost like a wall that they can't get over, and kind of put it behind them to kind of start fresh. John mentioned that I do some mediations. I remember one I had a couple of years ago. The parties had been divorced for 2 or 3 years. They had a cute little girl, and they were having trouble deciding how they were going to share the time with her. And They came in for a mediation, and I had them in my office sitting about as close as we are right now, and we were able to actually get some things on the table, they were able to discuss not just the issues related to the child, but some other hurt feelings that still existed from the divorce. And I don't want to get too touchy-feely and full of psychobabble here, but it did kind of air things out. And come to find out later when I talked to one of their attorneys, those two had not talked since they walked out of the final divorce hearing. One of them would pull up into the driveway of the other, the child would get out, would go in and come back, and that was it. That was the extent of their communication. And I think it came from, they had this history of being unreasonable, and once they kind of got things off their chest and could put things behind them, they were able to actually reach an agreement. And it helped a lot.
Mm-hmm. Well, those are the folks that do have reasonableness within them, but they just had not found it, and you were capable of drawing that out of them. John refers to folks who don't have a reasonable bone in their body, and there are a limited amount in the population, hopefully, very limited. But they are the difficult cases that create lots of conflicts for not only everyone around them, but most importantly their children, because it does appear that the children are the real victims in that unreasonable.
And I agree. The saddest part of this area of law is that when people get divorced, I tell clients, it's okay to hate your ex-spouse, but don't transfer that hate to your children, because you don't want your children to grow up and feel like they can't love both parents unconditionally. And we see it as lawyers, and the court sees it with people who just can't get over their hurt to leave their children out of this. I think the judge agrees with me, because we've had this come up before.
Mm-hmm.
I don't care if your children are 2 or 42. Don't involve them in your divorce.
Mm-hmm.
You're the parent and they're the child. And you just don't need to get them involved in it. But some people can't help themselves.
Yeah, I think more often than not it's an unconscious involvement on the part of the parent that they're doing it, and they don't even recognize that they're doing it. Sometimes it's a conscious effort, and that's really troublesome, but either way it still affects the child negatively, because inevitably what people don't want to admit to is that children by their very nature want to love their parents, and they want to love both their parents, and they want to think both of their parents are perfect and wonderful. And when you start tearing that down, it causes an impact, an emotional impact on the child, to their self-esteem, and a lot of issues arise not only at that time but certainly down the road as adults.
I think we can probably all three have enough experience. We've seen that situation, and we can predict that 5-year-old child, when they're 18, is probably going to have a lot of issues, maybe even before 18, but certainly by the time they're 18, they're going to have a lot of issues.
Mm-hmm. The largest of which I think is anger.
Absolutely.
Seems like anger manifests itself in teenagers that have parents who do not get along more than any other teenager.
And I think the other thing we should mention, if you're putting your child in that situation, you run the risk, even though you think you're really bonding with them and you're attaching them to yourself, that when they become a teenager, they will rebel and they will absolutely go over to the other parent.
Mm-hmm. Yeah, that does seem to happen inevitably, and it's just a matter of time. It may be way into adulthood before the adult child at that point, realizes what had gone on. It may be after one of the parents die and they reunite with the estranged parent, but inevitably there's going to be something lost in that whole process that a child's going to be bitter about.
And I think that we need to be clear, because it's not just a matter of trying to talk with the child directly about, well, look what your daddy did, look what your mommy did, and trying to get the child on your side. I think that children feel put in the middle when parents are communicating through the child, sending notes back to the other parent in the child's backpack or things like that, because the parents, they've got that wall built up between them that they just refuse to pick up the phone and talk to each other directly. Mm-hmm. I think that sort of thing happens probably most often. And parents sometimes have a hard time seeing anything wrong with that. And,
Right.
and when you're in this field of law every day, day in and day out, you can immediately see that's just a big storm brewing.
Right.
And some of those children get put in the middle and become the adult. They become the mediator between their parents.
I see that a lot. It's funny, there's a fine line between sitting down at dinner after you've had visitation, say with your father, and the mom saying, how's your dad doing, versus what's your dad doing, or what's he up to these days. If there's a genuine concern about the parent, they'll recognize that. If it's an attempt to interrogate the child into finding out who dad's sleeping with, or what he doing with you on his time, making sure everything is kosher, then a child perceives all that. And sometimes it's just a very fine line that parents cross over and they don't even realize it. So I really expect people to try to be cognizant of their communications with their children and put the best light forward about the other parent whenever possible.
Go ahead.
One thing that I get from people all the time is, well, I needed to talk to my child and make sure that everything is okay over there at my ex's house. And, what I tell people is, you can figure that out without interrogating the child and putting them under the hot lights and, browbeating them over it. If a child is not being taken care of, good parents are going to see that. If the kids are coming home and it's apparent that they have not had a bath for 2 days, or that as soon as they walk through the door, they're emptying out the cabinets, they're probably not getting fed properly, or whatever, all these things that we get calls about day in and day out, you're going to be able to tell it. You don't have to then go in and browbeat them and what's your dad doing, who's he sleeping with, what's he doing now, et cetera, et cetera.
The other thing is, a lot of children are so compliant, they will just learn to say what that parent wants to hear. If that parent says, well, you were with your dad all last week, he didn't brush your teeth a single time, did he? And they'll just probably say, no, he didn't brush them. Because if they say he brushed them, then they're going to argue. The mother's going to argue because she wants daddy not doing what he's supposed to do. And, it was the old story years and years I used to hear when I was a young lawyer and naive. The fathers would come in and say, my child tells me they want to live with me most of the time. And so I thought, as a young dumb lawyer, I thought that meant that, hey, we should change custody. I've subsequently learned through years of experience, didn't take years actually, but it took a little while, that children typically say that. They want to be loved by both parents, and if they know one of the parents wants to hear, oh, I really wish I could live with you, they'll say it every time they see it, and that would typically be the dad they're saying it to. And they mean it to the extent that really what they really wish most of the time is they wish mom and dad could live together again. They could be back maybe in a happy household, although a lot of those children were not in a happy circumstance when mom and dad did live together, but they perceived that it was a happy circumstance.
Kids can pick up on what the parents want to hear. And
Kids are amazing.
And they can truly pull the parents' strings.
Absolutely.
Well, we're about to wrap up another segment of the People's Law School. This segment's been about domestic relations. Jeff, is there any final words in about 5 to 10 seconds or less?
Most important thing is to be reasonable, if not for your own sake, for the sake of your children.
Anything, John?
I'll second that since we're running out of time here.
Well, this has been a pleasure, both John Reed and Jeff Alford joining myself for the domestic relations family law section of the People's Law School put on by the Bar Association. Thank you very much.
Thank you, Joe.